Welcome to Economics Made Easy. Today, I'm going to introduce a new perspective on how to view discrimination from the viewpoint of economics. We've already talked about scarcity. When things are limited, you have to make choices. Once you make a choice, you must have criteria for your decision. And these criteria inherently involve differentiating between options. Differentiation is discrimination. Scarcity, choice, differentiation, and discrimination are four interconnected concepts. Having one means you inevitably have the other three. In other words, we can't avoid discrimination. We can only discuss when will people discriminate, what the conditions for discrimination are, who gets to discriminate, and what the consequences of discrimination are. We can never avoid discrimination. For example, resources are limited. If you use a piece of wood to make a pencil, you can't use it to build a house. Time is limited. If I go to the movies tonight, I can't stay home watching TV. Money is limited. If I buy a record by Wang Fei, I can't buy another artist's album. When I buy Wang Fei's record, I am discriminating against other artists. If you don't like to call this discrimination, we can call it differentiation. But no matter what you call it, it's essentially the same thing. When I married my wife, I made a choice. By marrying her, I discriminated against all other women in the world. And I also discriminated against all other men, because in some countries, same-sex marriage is allowed now. Although I would like to treat everyone equally, the law doesn't allow me to do so. So, as long as scarcity is inevitable, choice is inevitable, differentiation is inevitable, and discrimination is inevitable. At this point, you might think, this is too repetitive. You're just saying that when resources are limited, you have to differentiate, right? Yes, this idea seems simple, but many people say it and then forget about it. It's not so easy to understand. Many countries around the world have anti-discrimination laws. For example, the U.S. has anti-discrimination laws, and the goal of the civil rights movement was to ensure that marginalized groups also received equal treatment. Many universities, to avoid discriminating against African American or other minority students, have policies to give preferential treatment to minority students in admissions. But what are the consequences of this? Does having affirmative action clauses and policies for equal rights mean that discrimination disappears? In 1978, the U.S. had a famous case called Regents of the U of California versus Back. In this case, the plaintiff, Back, was an engineer who had studied engineering earlier in life. After serving in the Vietnam War, he saw many injured soldiers and developed a desire to become a doctor, so he decided to apply to medical school. However, he was in his 30s, and back then, U.S. universities had serious age discrimination, believing that someone in their 30s shouldn't pursue higher education. He was rejected by all the universities he applied to. He later discovered that the University of California had a special policy to assist disadvantaged groups, reserving 16 spots out of 100 for such students. Because of his age, Back thought he should qualify as a disadvantaged group, so he applied to the University of California Davis Medical School under that policy. In reality, his scores were just 2 points short of the required threshold for admission. However, he never expected that, because he was white, the university would not consider him a disadvantaged group. They explicitly told him he could not use this policy to gain admission. Back felt discriminated against and took the university to court. The University of California had a clear policy to assist disadvantaged groups, but these groups did not include white people. Is this a form of discrimination? You see, the policy meant to eliminate discrimination actually led to new forms of discrimination. This is known as reverse discrimination. The case eventually reached the U.S. Supreme Court. Interestingly, the opinions of the 9 justices were highly divided. They issued a total of 6 opinions. In simple terms, the majority opinion was that schools can give preferential treatment based on race without violating the Constitution. However, implementing rigid quotas was deemed unconstitutional. In other words, you can assist disadvantaged groups, but you can't openly implement fixed quotas or numeric targets as part of affirmative action. In the end, Back was allowed to attend the school. What's most interesting about this ruling is that, despite all the legal arguments, the justices failed to grasp a fundamental point. Due to the scarcity of resources, the total number of admissions can only be 100. This necessitates some form of discrimination, some form of differentiation. If you favor one group, another group will inevitably lose out. If you don't openly disadvantage white people, you will have to quietly favor black people. Because of this logic, one of the justices publicly stated, "In order to treat people equally, we must treat them differently. We cannot and dare not let the Equal Protection Clause extend racial superiority." What he meant was that, in order to be fair, we have to discriminate against white people and give preferential treatment to black people. Another justice countered by saying that the judges who voted in favor of affirmative action were essentially advocates of reverse racial discrimination. These justices missed the core point. Any form of selection will inevitably involve a standard, which is, in fact, discrimination. Discrimination, due to scarcity, is unavoidable. If I were to rule on this case, I would say, first, because resources are scarce, schools must inevitably make choices when admitting students. Choice is unavoidable, and with choice comes discrimination, which is also unavoidable. Whether you're for or against affirmative action, no one has the right to claim neutrality. Every position is inherently biased. Second, since discrimination is unavoidable, the focus of our discussion should shift to two other questions. 1. Who has the right to discriminate? 2. Who bears the consequences of discrimination? Third, schools are the entities making the admissions decisions, so they have the right to set any discriminatory criteria they wish. Schools can choose to admit students from disadvantaged groups, even if their academic scores are lower, or they can admit athletes with lower grades if they bring value to the institution. The schools are entitled to do so because they are the ones making the admissions decisions. Whether the policy is explicit, like having rigid quotas to support disadvantaged groups, or implicit, where the disadvantaged are quietly favored, both are acceptable. However, the school must bear the consequences of its discriminatory admissions policies. Fourth, beyond the schools, employers who hire graduates, the ultimate beneficiaries of the admissions policy, should have the right to know why each student was admitted, whether it was due to academic excellence, athletic ability, or race or ethnicity. They should have the right to this information. This case is complex and a landmark case, but the key takeaway is something that most people tend to forget. Scarcity inevitably leads to discrimination. The question is not whether we should discriminate, but rather, how should we discriminate? Many people like to say, "I don't support equality of outcomes, but I advocate for equality of opportunity." Do you think this statement is meaningful? Feel free to leave me a comment, and I'll see you next time. This is Economics Made Easy, where we give you authentic economic thinking.